I'm going to present the topic on imputability of infringements in European competition law. In society, we often have a debate as to how responsible parents are for the actions of their often unruly children. Also, in the military, when there is a war, the debate centers around whether an ordinary foot soldier is responsible for his actions when he was taking orders from the high command. In EU competition law, we have imputability of infringements. That is to say that the conduct of the subsidiary can be imputed to the parent company provided certain conditions are met. The basis for this doctrine lies in the idea of the single economic entity. This takes us back to one of the basics of EU competition law. The decisions are addressed to undertakings or to legal persons. This comes from the case of Limburgse Maatschappij. If a concerted practice, an agreement, etc. is deemed to have taken place inside this one economic unit, it will fall outside the ambit of Article 101 TFEU. Let's look at some case law. The parent and the subsidiary, in Big Geilan, import, Article 81, as it was then, would not apply to an agreement between a parent and a subsidiary which, although having separate legal personality, enjoys no economic independence. And this is a very important principle of EU competition law, that the legal definition of a company does not always correspond with the economic definition in competition law. Another example is Centre Farm, in which the Court of Justice held that Article 81 is not concerned with agreements or concerted practices between undertakings belonging to the same concern and having the status of parent company and subsidiary. Another notable case is Viho against the Commission, where Parker Pen held 100% of the shares in the subsidiary companies, they directed their sales and marketing activities, and it controlled sales, targets, gross margins, sales costs, cash flow, and stocks. The court held that Parker and its subsidiaries thus form a single economic unit within which the subsidiaries do not enjoy real autonomy in determining their course of action on the market. Where there is a situation of multiple ownership, it's slightly more complex. We have guidance in the case law of Gosma Martel, where the parent company was a joint subsidiary of Martel and Piper Heidsieck. The Commission found that Martel was not in a position to control BMP's commercial activities because the parent companies each held 50% of the capital and the voting rights. The Commission therefore concluded that the parent company and the subsidiaries were independent undertakings. There is a retrospective aspect to this. That's to say that if the subsidiary, prior to an acquisition by another undertaking, had carried out anti-competitive practices and the mother company still exists, the mother company will still be liable for the offending conduct of its former subsidiary prior to the takeover. Furthermore, a parent company may be fined for the conduct of a subsidiary which is acquired later, at least where it continued to pursue the same policy after the acquisition, and Suiker Unie is our guide for that. A crucial aspect of this, the consequence, is the extraterritorial aspect. That is to say that companies, parent companies, outside of the Union, we have subsidiaries who operate in the internal market inside the European Union, can still be called by this notion of a single economic entity where the anti-competitive behavior can be imputed to the parent. We have the guidance from this in the dyestuffs case and subsequently wood pulp. The interesting aspect to note here is that the European Court of Justice has eschewed the option of referring to the effects doctrine, which is very popular in US competition law arising out of the famous Sherman Act, and has instead relied on the idea of the single economic entity to punish conduct, anti-competitive conduct, which has had appreciable effects inside the internal market, the single market, even where the parent company is based outside. In fact, in the dyestuffs case, the parent company was based in the United Kingdom, which at that time had not yet become a member of the then EEC. This is very important because increasingly, and it was true to a certain extent 40 years ago when dyestuffs was decided, but even more now, more than ever, we live in a global market as a result of the forces of globalization, and it is vital that EU competition law is not blind to the reality of the market. Otherwise, you could have companies who are based in Australia, the United States, Canada, Japan, who could just back off and they could let their subsidiaries take the flak, and this would not be an optimal solution for enforcing competition law inside the market and ensuring fair competition on the market for consumers. The other consequence is financial in nature, and that revolves around the calculation of fines. If we look at Article 23.2 of Regulation 1/2003, it tells us that the Commission may impose fines on undertakings and associations of undertakings, but the fine shall not exceed 10% of its total turnover in the preceding business year. Where the infringement of an association relates to the activities of its members, the fine shall not exceed 10% of the sum of the total turnover of each member active on the market affected by the infringement of the association. We're dealing mainly with undertakings here, and evidently the parent company will have greater sales and greater resources, greater turnover than the mere subsidiary on its own. Therefore, the 10% threshold is 10% of an altogether much greater sum. This increases the amount that the Commission are able to fine companies, and therefore it is in the interest of parent companies to be able to say that they were not responsible for the behaviour of their subsidiaries. Given that increased fines have been imposed as a result of the imputability of infringements due to the obviously greater financial resources of the parent company, it has to be asked whether this is an entirely desirable consequence. And it has been argued that the fine race between national competition authorities and the Commission to see who can fine the most money has negative consequences. As Durevery points out, the most severe fines draw funds out of the business which may otherwise be used for investment, research and development, keeping jobs going, and therefore the future of the company could be placed, of the parent company could be placed in doubt through something that may not have had direct influence which was happening in the subsidiary. The former president of the General Court, Bo Westerdorf, makes the point that the reason for increase in fines in order to act as a deterrent comes about also because the idea of criminal sanctions, and although there are those who believe that there are criminal sanctions in competition law, but criminal sanctions, officially criminal sanctions, do not exist at the union level for undertakings found liable for anti-competitive practices, particularly in relation to cartels. We now move on to a situation where the parent owns 100% of the subsidiary. And what exactly is the situation here? Where a parent owns 100% of the subsidiary, there is a rebuttable presumption that the parent company has direct and decisive influence over the actions of a subsidiary. However, it must also be understood that this does not of itself automatically impute the infringement to the parent. It merely creates a presumption which is able to be rebutted. The basis of this, or the main basis of this, is the AkzoNobel case, P11205, which was appealed and upheld by the European Court of Justice. And AkzoNobel, their argument centered around the exact role that the parent company should have in relation to a subsidiary, because they argued that it should only be commercial policy which is taken into account when assessing whether the parent company was responsible. However, there are a whole host of other matters which the Commission took into account in order to find, and the Court of First Instance, as it was then called, took into account in order to find AkzoNobel liable as well. In any event, if we discard the other factors, the non-commercial factors, the very fact that AkzoNobel held 100% of the shares in its subsidiary was in itself enough on its own, without any other factors, to create a rebuttable presumption that AkzoNobel exercised decisive influence over its subsidiary. And if we look at what the Court of First Instance said that it found that AkzoNobel played a key strategic role in areas beyond the scope of commercial policy, such as setting overall group targets, limits within which investments could be made, internal auditing had to be reported to the parent company, advice when drawing up the overall operational plan of the business, human resources, and legal affairs. Therefore, the relationship obviously touches upon a number of essential aspects in a business beyond the strict, narrow confines of commercial policy, and it was no longer, therefore, the sole factor. This was a decisive step taken by the Court of Justice, and of course by the Court of First Instance beforehand, upheld by the European Court of Justice. When the case went on appeal to the Court of Justice, the previous case, Stora, featured heavily, and AkzoNobel had argued that in Stora, the Court of Justice had held that the 100% share ownership did not in itself trigger the rebuttable presumption. However, Advocate General Court and the court itself held that the fact that the Commission had used further reasoning, and that, for example, it was not disputed that the parent company did indeed exercise influence, was only in order to give additional grounds for the reason. It was not in relation to creating the presumption that is able to be rebutted. And the Court of Justice held that the 100% on its own is enough. Once the Commission shows 100% of share ownership, there is a presumption that it is for the parent company to overturn. And again, we go on to what factors need to be taken into account. And the Court of Justice said that all relevant factors relating to economic, organizational, and legal links which tie the subsidiary to the parent company, which may vary from case to case, and cannot therefore be set out in an exhaustive list, at the end of the quote, must be taken into account. Now, this raises a question of whether the burden and the standard of proof have been altered in an unfair manner. The Commission only established the standard of proof, i.e., that they had to show the 100% of share ownership. That was all. The burden of proof was still on the Commission to show that a decisive influence had been exercised over the subsidiary, and as we will see later, the Commission still has to comply with all the procedural requirements which are known in union law. Furthermore, the 100% rule, according to Advocate General Court, provides legal certainty, and the presumption is not without good reason. We will return to this. Subsequently, AkzoNobel has not been rebutted in the case of Quimica, which in fact strengthened the jurisprudence of AkzoNobel of decisive influence of a parent over a wholly owned subsidiary to cases where the subsidiary is indirectly owned by the parent, at least where the 100% ownership chain is uninterrupted through the various levels of the organizational hierarchy of the ownership structure. And the court held that in the specific case where a holding company holds 100% of the capital of an interposed company, which in turn holds the entire capital, so you see we're continuing the 100% chain, the entire capital of a subsidiary of its group, which has committed an infringement of EU competition law, there is a rebuttable presumption that the holding company exercises decisive influence. Factors which are considered insufficient in order to rebut the presumption include group-wide competition compliance policy put in place by the parent. This comes from OTIS. Interlocking board memberships, i.e. wholly separate boards. If there are separate boards for the two companies, this does not in itself suffice in order to demonstrate that the subsidiary has acted autonomously, and that's from Dyson Group. Limited involvement of the parent entity in the commercial policy of the subsidiary, alpha then. Again, we have the idea of the solely commercial involvement. And indeed, there were three possible exceptions which could rebut the presumption. For example, if 100% of the shares are held temporarily or for a very short period of time, or if for legal reasons the parent company is unable to exercise its direct influence. And the third, which all three of which were proposed by Advocate General Court, The third, which was taken up in Alliance 1, and that's where the interest is purely financial. Although in Alliance 1 it was not 100% shareholding, therefore it is fair to say that in Action Noble, where there is 100% shareholding, that has not been overturned. A slight get-out clause has appeared in the form of procedural requirements, which the Commission, as the competent competition authority, is required to adhere to. In early case, the Court of First Instance held that the Commission is required to provide sufficient reasoning for its decisions and to address relevant arguments put forward by the parent company in relation to the interaction between itself and the parent company, such as no interlocking board memberships, subsidiaries, chairman and chief executive, having considerable autonomy, and evidence was produced to back that up, having its own sales, marketing departments, etc., the fact that it had the sole responsibility for pricing strategy. I mean, that's not to say that the arguments would have rebutted the presumption, but the Commission only paid lip service, and therefore they didn't adhere to all the procedural requirements they were supposed to. In Vorengelijke Gross, once again procedural grounds came to the rescue of the parent company, as the Commission failed to specify whether the individuals who took part in cartel meetings belonged to the parent or the subsidiary, and furthermore the Commission failed to provide adequate reasons. In Elfaki 10, which was 98% ownership of Alfima, the subsidiary, the Commission once again failed to state adequate reasons and address the arguments of the parent company. It has been claimed that these decisions are derogations from AXO. These decisions are derogations. However, these are procedural requirements, and while not unimportant, it does not alter the fact that there is the 100%, when there is 100% ownership, there is a rebuttable presumption that the parent company has exercised decisive influence, and if it fails to rebut that presumption, then the anti-competitive conduct will be imputed to the parent company. If we look at another case where it was less than 100%, Gotteland and Stichting Administratiekantoor voor Deeltje, the presumption was actually rebutted, the presumption of decisive influence, because the first meeting of the Board of Directors of Fort Deeltje took place 2 years after the end of the infringement, and the only activity of the parent company to exercise the rights was voting at the annual general meeting. That was the only time it could influence the policy of the subsidiary, and no such meetings were held during the relevant period of the infringement. If we go through a few other issues, whether a presumption should exist, Advocate General Cotte believed that the idea of presumption should exist was justified because it created legal certainty. But why is there a presumption? It's because of the common practice, and I believe that this is correct, because if the court is slow by sticking to purely legal means, if it's slow to recognize the entirety of workings which take place inside a business, then it provides a sizable loophole for parent company to complain, or to claim successfully, that they had nothing to do with the anti-competitive practice of the subsidiary. However, if you have a large ownership stake in a company, and especially if you have 100%, it's very unlikely that the businesses will turn the other cheek and ignore completely the activities of the subsidiary. And especially where subsidiaries having to take a great risk, it knows it could incur a great fine, so it is likely that it will seek the approval, tacit or otherwise, of the parent company. That fines have been ever increased gives rise to the dissuasive nature of the fines, although this has not entirely worked because there are still being fines imposed of ever higher amounts, not necessarily because of the trend towards that, but because companies are still committing anti-competitive, are still guilty of anti-competitive behavior on the market. However, one must be careful. In Worldwide Tobacco España, the Court of First Instance held that the objective to be pursued is to guarantee the effectiveness of the fine by adapting the amount with due consideration to the global resources of the parent company. However, if this is the only reason taken into account by the Commission and the Court, then it goes beyond the principle of proportionality and is deemed to be excessive. Finally, the European Court of Human Rights has been asked to rule on whether the principle confirmed in AXO runs contrary to the presumption of innocence from the right to a fair trial under Article 6 of the Convention. This will take years to go through the Strasbourg courts, owing to the slow nature of litigation in Strasbourg. However, in the General Court, in the case Elevators Escalators, decided Strasbourg jurisprudence itself, in order to maintain that presumptions of fact or of law can be made in the domain of criminal law without breaching convention rights, subject to reasonable limits and maintaining defence rights. This, of course, will become a much greater issue once the European Union, as expected, accedes to the European Convention of Human Rights. Thank you for listening.